SJC 10268, Middlesex Retirement System versus Billerica Board of Assessors.
Thank you. Mr. DeCourcy.
Thank you, Your Honor.
Hold on just one moment. We want to get the clock straight. Okay, thank you.
Thank you, Your Honor. May it please the Court. My name is Stephen DeCourcy, and along with John Lynch, we represent the appellant, the Middlesex Retirement System, LLC. Your Honor, the issue before the Court today is a decision resulting from the Appellate Tax Board, and the question is whether the real and personal property used in the operation of a public retirement system that covers employees of municipalities and other governmental subdivisions is exempt from local property taxation.
Mr. DeCourcy, why is it that the MRS decided to create the LLC to purchase this building?
Your Honor, I wasn't involved in the decision. The decision was made between the time a purchase and sale agreement for the property and the acquisition of the property took place. The LLC, I believe the sole reason probably would be just the protection of the investment funds of the retirement system itself. They're approximately from what? From slip and fall?
Well, liability, yeah.
Possibly for premises liability, Your Honor. That's really the only.
Is the retirement system not covered by the tort statute, the Massachusetts?
No, my understanding is that it is, Your Honor. And in fact, the board members of the retirement system are indemnified and covered under Chapter 258. Whatever reason, between the time the P&S was signed and the property transferred hands, a decision was made upon the advice of counsel to place the property into an LLC, the sole member of which was the retirement system.
I think, if I recall, the defendant mentioned somewhere in its brief that it was assuming that the development of the LLC, the establishment of the LLC, was to avoid tort liability. And there's no evidence in the record anyway. Let me ask you this. Is there any evidence in the record that the LLC was created to avoid tax liability?
No, there's no evidence in the record at all, Your Honor. In fact, it really would have no tax implications whether the retirement system held the property in its own name or created the LLC. So in that instance, where you're dealing with property, the beneficiaries of which retirees and active members of the retirement system, there is a fiduciary duty. Arguably, the beneficial interests of some of these investment funds are in the actual members. So any steps that the retirement system took, whether it was necessary or not, to give them that added level of protection, or what they perceived to be an added level of protection, they felt was consistent with their fiduciary duty in the operation of the system.
Let me ask you this. Let's assume, and I'm really confused about who's been assessed what, but I'll get to that in a moment. But let me ask you this. If the Middlesex Retirement System, as an investment, went and bought a commercial building in Billerica, would you be taking the position that that asset is not taxable for real estate tax purposes? An investment.
Okay, and the use of the building, commercial. Okay, commercial building, they have commercial tenants. In that case, if the building was occupied by commercial tenants, it wouldn't be occupied, the occupancy of those tenants would be for other than a public purpose, and the assessors would have the ability under Chapter 59, Section 2B, to actually assess those tenants, not the retirement system, for their use and occupancy of the property.
They could do that with your tenants. Yes, that's what I was going to say. That would apply to your tenants as well.
That's correct, Your Honor.
So your tenant should be assessed the remainder. You should be exempt for your part that
correct.
You use, but your tenant should be assessed for the remainder.
Right, and what we alleged in what was at issue in the appeals, Your Honor, is that because the assessors of Billerica did not issue tax bills under 59.2b, they issued it directly to the retirement system. The bill to the retirement system is completely exempt. But going forward, there's no dispute that Hart Hanks is a commercial tenant. They're on the first floor of the property. There's no dispute that if Hart Hanks had received a tax bill from the assessors, that would have been an appropriate tax.
But can I ask you this? I'm looking at Chapter 32, Section 19, exemption from taxation. The funds of each system, and I understand that I sort of understand the reason why this exemption is here. We're talking about the funds held by the system. The funds of each system established under the provisions, so far as they are invested in personal property, shall be exempt from taxation. But what about the funds, which I take it the funds of the system were used here to purchase this building? What about funds used to purchase real estate for commercial purposes? Why isn't the system itself taxable for that rather than the tenants?
Yes, Your Honor. The authority which the retirement system received to acquire property, both real and personal, comes from Chapter 34B, Section 19. 34B, Section 19, subsection L, states that where Chapter 32 would apply to this retirement system unless its provisions are inconsistent with Chapter 34B, where the legislature has given the retirement system the ability to acquire property, I would argue that to the extent that they issued that grant, that is what allows the retirement system to purchase the property, and that's what would make that property exempt.
Now, my second question relates to the assessment of personal, what they call personal property taxes?
Yes, Your Honor.
All right. Who was assessed those taxes?
Yeah, and there's a great deal of confusion in the ATB finding, and the taxes were assessed to the LLC. The retirement system has maintained all along that the personal property is owned by the retirement system. In fact, the agreed exhibits, the exhibits that went in with the agreed statement of facts, includes annual financial statements, annual reports to PERAC, who has overall supervision of the retirement system. And in those statements, signed under the pains and penalties of perjury, the retirement board says the personal property is owned by MRS, and the real property, the title, is in the name of the LLC.
Okay, and the Form 2s, whatever they are, that the town sent, were they sent to the LLC or to the retirement system?
Oh, well, there is an exhibit that contains a letter from the chief assessor from Billerica, who, by the way, is a member of the retirement system as a public employee. But that letter was addressed to the Middlesex retirement system. It was not sent to the LLC. And that form of list requirement, which is cited in the appellee's brief, Chapter 59, Section 29, only requires a taxpayer to report their non-exempt property. It's our position that the LLC doesn't own any personal property, so they never had an obligation to file the form of list. The retirement system doesn't own any taxable property. So again, the requirement of Section 29 doesn't apply.
Does the record tell us how many retirement systems, how many other retirement systems are there in this state? Do we know that?
Well, there's 106 retirement systems across the state, Your Honor, and that is in, I believe, in one of the agreed statements that we talk about us being one of 106, including the state system.
And are they all exempt? Is it your position they're all exempt?
Yes, Your Honor. Yeah, and again, this Chapter 34B really only applies to the retirement systems that were in place in counties that were abolished in 1997.
I have a question about the personal property, and I don't understand the statute. If you look at Clause 8 of Chapter 59, it says that if property is exempt, eighth, personal property of any retirement association exempted by Chapter 32, Section 19. Chapter 32, Section 19 refers to the funds of each system, blah, blah, blah. But there's no personal property tax on money anyway.
Right.
So I don't understand that.
Yeah, Your Honor, this statute was actually picked up, or this section was enacted about 100 years ago. And I think the only explanation I can make for it is that there was a concern that the beneficiaries of these funds were the retirees, so that to make it clear that the beneficial interests were never taxed, Clause 8 was enacted. And in fact, one of the major underpinnings of the ATB decision is that because Clause 8 exists, we don't even get to Clause 2 in property of the Commonwealth. And the ATB basically said that you look at that statute, it refers to personal property, and the expression of that exemption means that no other exemption applies. But the very first paragraph of Section 5 of Chapter 59 says that of the 55 exemptions that are contained in Section 5, there are 16 that if you qualify for that exemption, you do not qualify for another. Clause 2 isn't one of them, and Clause 8 isn't one of them. And so therefore, you really have to look at the statute as a whole. Looking at the statute as a whole, Clause 2 and Clause 8 aren't inconsistent, especially when you consider you're looking to protect the investment funds from taxation in Clause 8. In Clause 2, it's really the property of the Commonwealth. And I will point out, especially with respect to the personal property, The employees of the Middlesex retirement system, the full-time employees who work over 20 hours a week, are members of the system. They are public employees. So if the board were to, or the court were to affirm the appellate tax board, we'd have the unusual situation that public employees are working at property, desks, furniture that is taxable in carrying out the administration of the government. It just doesn't make sense.
So Clause 8 doesn't make sense, in other words.
Well, no, not that Clause 8 doesn't make sense. Clause 8 is just a statement, again, probably out of a concern for the beneficiaries, that any of the investments, and remember, the funds of the retirement system include employee contributions as well as funds that come from the various member units. That is going to be exempt from taxes. And I think when you look at it that way, it is consistent.
I appreciate your argument that the sole member of the LLC is the retirement system, and that's the, in form, that's who, I mean, in substance, that's who matters, not the LLC. But we have, you know, a number of cases that sort of say, if the statute says, for example, corporation LLCs aren't included, if it says something else, LLCs aren't included. So why isn't it correct that even though that's true, because you chose this form of a foreign LLC, that you've got to live with the choice that was made, and at least the real estate is taxable?
You run a couple of things. One, the authority which the system received to purchase this property came through Chapter 34B, where the legislature has given a general grant of authority, and the system had a choice. They could either lease property or acquire property. Then the agency's determination that the best form for that ownership should really be respected. A few cases that the appellee has cited with respect to specific forms, the LLC form that was at issue in RCN, that dealt with LLCs who are subject, or corporations that are subject to tax under Chapter 63. It's much more specific than the broad language in Clause 2nd, which is just property of the Commonwealth. And because 34B gave the system the right to acquire property, the system's decision as to its form should be respected by the board and should be upheld here. And the other thing I would say is that the system itself is the sole member. It's making all the decisions with regard to the LLC. The title, while the title is in the name of the LLC, the benefit of the ownership isn't necessarily to the system, but it's to the members and to the various municipalities and political subdivisions by separating that asset and protecting it as much as it can.
Going back to the personal property, helping understand your position as to why there's no obligation of the MRC to tell the town that we own this property.
Well, the obligation, Your Honor, is that the form of list is the requirement to file a form of list is contained in Chapter 59, Section 29. That's the only request that was made for the filing of a form of list. That states that any taxpayer must report its non-exempt property to a municipality. There is no non-exempt property in the position of the retirement system here, so there is no obligation to file the form of list. As for one thing I want to point out is the town of Billerica.
No obligation to file a form, or no obligation to file a form that says we have no non-exempt property. I mean, otherwise the town is sitting there with nothing.
Well, the town is a member of the retirement system itself. The town has interaction with the retirement system. The town knew, in this instance, exactly what was going on with the retirement system and what the interaction was by virtue of being one of the member units. But the Section 29 requirement that the ATB relied on, if we were to have filed a form of list, I think it could be argued that we waived our right to claim that the property is exempt from taxation. The Section 29 doesn't require an exempt entity to file a form of list saying they're not taxable. It only requires the entity to report its taxable property.
And what about your argument that the board sent the notice to the wrong party? Is that part of this same argument, that it went to the LLC instead of to you?
Well, that's part of the confusion in the board's decision. The board is saying the LLC didn't file a form of list, but the request for the form of list was addressed to the retirement system itself.
Which is exempt.
Which is exempt. That's right. Just a couple more things, Your Honor.
You have 30 seconds.
30 seconds, okay. I think you can clearly hear the public policy principle that property of the government, or instrumentality of the Commonwealth, should not share in the burdens of the operations of government. That actually diminishes the ability of the system to operate, and to affirm the ATB's holding would really run counter to that public policy requirement. Thank you.
Thank you, sir. Mr. Costello.
Thank you. Good morning, Justices. My name is Patrick Costello. I'm with the law firm Lewis & Costello, Condon and Pfaff. I am town council for the town of Billerica, and I'm representing the Billerica Assessors in this appeal here today. The arguments here today, Your Honors, are based solely on the provisions and construction of provisions of general law that apply to local taxation.
And you're not, I just want to be certain, you're not claiming that the Middlesex retirement system created the LLC in order to avoid taxes, are you?
We have no idea why they created the LLC.
Well, you don't make that claim.
We don't make that claim.
Okay.
I can say, Your Honor, that typically LLCs are created, particularly out-of-state Delaware LLCs are created for financial, tax, liability, insulation reasons.
But if the retirement system owned this building directly in its own name, would you still say it's taxable?
No. We deny that.
None of it's taxable, even though some of it's used for...
Oh, no, I'm sorry. I misunderstood your question, Your Honor. We deny that it's exempt from taxation.
You would say it is taxable?
It is taxable, yes.
The whole building?
Even
Absolutely.
if Middlesex retirement system owned the whole building, even if it was used entirely for public purposes?
We would take that
Why?
position, Your Honor,
Why do you
because
say that?
the law in this Commonwealth, as this Court has established it, is very clear that the general rule in Massachusetts is all property, real and personable, is
Do you have
subject to
any- Do you
taxation.
have any cases in which a retirement system has been subject to local tax like this?
We don't, Your Honor. I would suggest this is a case of first impression in the Commonwealth. This issue has never arisen before. And in large part, this issue has been spawned by the abolition of various counties and the spin-off of the retirement systems
Well,
under...
there still are a whole bunches of local retirement systems that are in counties that haven't been abolished, right?
There are indeed, Your Honor. I do not know what the tax status of those properties is. We would suggest, however, and the position we have taken in our brief, is that unless there is a clear and unequivocal exemption provided in statute for real or personal property, the property is taxable. And I think there are numerous cases that stand for that proposition.
How do you answer, though, the policy argument? I mean, put the LLC to one side. So let's just focus on, let's say that we're just talking about the retirement system owned and used this property. Isn't it giving Billerica tax revenue that is really designed to be the retirement savings of many people other than the citizens of Billerica, because there are lots of other members of this particular regional retirement system? I mean, it just doesn't seem to me to, it seems to me there really is a policy issue here about one city or town diminishing the value of the asset for the retirement system that is a public retirement system serving public employees, part of the Commonwealth's overall system.
Your Honor, I believe to take this case to the extreme situation, if a retirement system in Massachusetts were to purchase and own the Prudential Center in Boston, utilize one floor of that building for itself, would that mean that that entire building is exempt from taxation?
No, I think the answer is that under Section 2B, the tenants could be taxed for the other 59 floors.
And the applicability of Section 2B to this situation would be contingent upon a determination that the retirement system is the Commonwealth of Massachusetts. And I don't believe that that is clearly the case under the statutory scheme. I would suggest that under the provisions of Chapter 59, Section 5, there are numerous situations where public or quasi-public type agencies are granted some or complete exemption from real and personal property taxation. There are situations where there are power companies, water companies, agricultural societies that do serve a public or quasi-public purpose, which by the very language of that statute are given specific exemptions from real estate and personal property taxations. They may be complete, they may be partial, or only one class or the other of property. I would suggest that the legislative intent behind Section 5, which is a very voluminous and comprehensive section, is to lay out with detail and with specificity the exemptions from the general rule of taxation, so that to the extent that a retirement system does not expressly and unequivocally qualify for one of those specific statutory exemptions, it would not be entitled to an exemption. It is illustrative, I believe, of the legislative intent that Clause 8 of Section 59.5 does grant a partial exemption of certain personal property owned by retirement associations. As was noted earlier, that personal property exemption seems to relate only to funds of the retirement systems that are invested in such personal property. It protects the income and the annuities and long-term investments of retirement associations from taxation. Had the legislature intended to impose a broader or more comprehensive exemption on whether it's personal or real property of such retirement associations, it very easily could have incorporated such specific language into that clause or a different clause of Section 5.
But on the other hand, the argument is funds are different. The funds of all of these people that the retirement system handles is different, obviously, than the property the retirement system owns to do its business. And if the first is covered by Section 5, property of the Commonwealth, there may be still some need for protection for those funds that they manage, that indeed, to clarify that those aren't taxable either. That's not really property of the Commonwealth. That's sort of property of the employees and the members of the system. So there is a reason why that clause, is it 8 or whatever it is? Yeah, that exemption might be there, and you could read it as not to say that's the only exemption that applies to retirement systems.
Again, Your Honor, I would note the general proposition of law that all property is subject to taxation unless expressly exempt. These retirement systems are a new breed of entity at this point in time, given the recent abolition of the counties.
Has there been any attempts to submit bills or introduce bills to the legislature to deal with this problem?
I don't believe they have, Your Honor. I think this dispute between MRS and the town of Billerica is the first instance in which this dichotomy of the laws has been brought to light. But again, the case law and the decisions of this very court over the last 20, 30 years are very clear and stand compellingly for the proposition that an exemption from tax is a privilege. And unless there is a very clear, direct statutory mandate that authorizes an exemption, the taxing authority is authorized and should assess the property. That is what the Billerica assessors did in this case.
Could I ask you another question?
Sure.
With respect to the personal property, assume for the minute that we're talking about desks and things like that, and let's assume for the minute that it is shown to be owned by the system and not the LLC. The Appellate Tax Board, and I take it your position is same result, because, and why is that?
There would be two reasons here, Your Honor. Number one, the appellant has failed to meet its burden of proof, again, which is clearly established as a matter of law to prove ownership of the property.
No, I know, but I'm assuming that they've done that.
Okay, assuming that they have, which we argue they didn't in this particular
the annual
case.
reports.
Correct.
Let's assume that that's an adequate demonstration that the property is owned by the MLS.
Our position would be the position that the Appellate Tax Board had adopted, that only certain personal property of retirement systems is exempted by Clause 8.
Why, I have trouble seeing, so you're saying if the retirement system invested in a Vermeer painting, that would be exempt because that's personal property held for investment, but a desk is not exempt because it's not held for investment? Is that what you're saying?
I believe the statute could be construed in that manner, Your Honor, yes. It is the legislature's prerogative to determine where and to what extent tax exemptions lie. We are working with the body of law that's set forth in Chapter 59, Section 5. I believe, as this Court has ruled quite frequently in the past, we have to take the entire statute and read its plain and unambiguous terms to construe the legislative intent behind the statute. And I would suggest that in this particular situation, where there is no express authorization of an exemption of real property or personal property, other than that referenced in Clause 8 and Chapter 32, Section 19, there is no basis for a claim of exemption from taxation.
Now, before Middlesex County was abolished, obviously this may be an obvious question, an obvious answer, it had buildings. It owned stuff.
It did not, Your Honor. At Middlesex,
It was in the courthouse.
the retirement system was housed in the treasurer's office
No,
of
but
Middlesex.
Middlesex County owns stuff.
Oh, correct,
They own the
yes.
hospital, they own presumably other offices.
Right.
Places where the registrar, well, I don't know. Is your position that you may not have had any Middlesex County-owned property in your town, but that Middlesex County-owned property would be taxable?
No, it wouldn't be. I believe that a county is a political subdivision of the Commonwealth of Massachusetts.
Okay,
and
so
thus would
by
be-
abolishing the county but preserving the Middlesex retirement system, they didn't preserve any protections for the Middlesex retirement.
What the statute did was abolished the county and enabled the Middlesex retirement system and other such retirement systems to continue to operate in accordance with new Constitution provisions set forth in Chapter 34B, Section 19.
Well, why isn't the Middlesex retirement system a subdivision of the Commonwealth, as counties were?
Because they're not under any direct control of the Commonwealth. They're under the control of an independent board of directors that is appointed by statute, much as a water company or an agricultural society, which may enjoy some tax-exempt benefits, be under its own constituted leadership.
Are they designated as state employees, for example, for purposes of filing statements of financial interest and things like that? Or is it-
I believe the directors are covered by the provisions of Chapter
But these
268A.
are all, everybody is still, who works for the retirement system, retained the same status as a
Public employee?
public employee.
It was somewhat modified, Your Honor, by the provisions of 34B, Section 19. It did indicate specifically who would serve on the new board of directors, and all those members of the existing governmental or man-force scheme of the county retirement system only remained in office until there was a transfer to the new governing regime.
How are they included under the Tort Claims Act? Or are they?
I don't know that, certainly the Tort Claims Act, Chapter 258, doesn't specify, much like the tax laws don't, whether county retirement systems are incorporated within the umbrella of protection. It would depend, again, on an argument of whether or not they were an instrumentality or agency of the Commonwealth, which, again, for taxation purposes, we would argue they're not. I would suggest that a similar such argument could be made for a plaintiff asserting a tort claim against the entity that is not an agency or instrumentality of the Commonwealth. I'm not aware of any prior law in that regard, Your Honor.
If the Middlesex retirement, getting back to Justice Cordy's question early on, if the Middlesex retirement system had purchased this property, the land, the building, as an investment, would you be making the same argument you're making?
We would, Your Honor, because we do not believe they qualify as the Commonwealth of Massachusetts.
But they're purchasing it for an investment. Why isn't it treated as the same as the Vermeer painting that you said would be recognized as an investment?
Because only investments in personal property are specifically exempted by the provisions of Chapter 32, Section 19.
Going back to that painting by Vermeer, is the entirety of your argument focused on the use of the word invested in Section 19?
With regard to the personal property, Your Honor?
Right.
No, there's a second argument that the town has made, and again, based on very well-established principles, that the burden of proof for establishing entitlement to an abatement or an exemption is upon the property owner, and that in this particular instance, despite two requests from the assessor of the town for information detailing the personal property at issue, that information was never provided. By law, the assessor is then entitled to make his own estimation of the value of that property, which he did do in this case, and there was never any further response or supplementation of information right up through the conclusion of the appellate tax board proceedings. So our view, as the ATB concluded, was that the appellant failed to meet its burden of proof to establish entitlement to the exemption.
But Mr. DeCourcy says we had no burden to provide it because all you asked us for was non-exempt property.
Well, I believe that gets back to the core issue in this case, whether or not the property is exempt or not. The town's position is that it is non-exempt, and obviously my brother's
So
position is
are
that
you
it's
saying
exempt.
that if we decide for the retirement system on the major question as to the real property, that will in your opinion, resolve the personal property question?
No, I don't believe it would in its entirety, because I do believe the Appellate Tax Board has a great degree of discretion in determining whether a burden of proof has been met to establish entitlement to an abatement or exemption, and the ATB has exercised its discretion in this case based upon the record of evidence presented to it and decided that there was not sufficient information provided.
I take it that you don't send a Form 2 to the sheriff of Middlesex County for the Billerica House of Correction, or maybe you do.
I think the forms of list go to the owners of property. I don't
So that would
believe,
go to who if you were to send it? To the state?
the common, I don't believe that, it's non-exempt entities that receive the forms of list, and the Commonwealth itself would clearly be exempt if.
Right, so you send it, but your argument is, well, we sent it to them, they didn't send it back. Ha, they've waived their claim to exemption. Is that right?
No, it's not. It's our
So if
position.
it's exempt, it's exempt.
We-
If Middlesex County, if the Middlesex County personal property is exempt,
If it meets
this
the
case, that part of the case is over.
if it meets the criteria in Clause 8 in Chapter 32, Section 19, only would it be exempt.
But not because they didn't send a Form 2 back. If they were an exempt organization, they don't have to send
No.
a Form 2 back.
No, one of the bases, however, upon which we supported the denial of the abatement application at the local level was the failure to provide information corroborating or supporting.
No, I
the-
understand that. But
Okay.
but if you send it to the Commonwealth of Massachusetts and they didn't send it back, you could hardly say, you didn't send it back. You
Right.
therefore didn't prove that you're an exempt. That would be kind of a ridiculous argument.
Well, if we would send one to the Commonwealth, first of all, Your Honor, but if we would send one to Gillette Corporation and
No,
they
I'm
failed
talking
to
about
respond-
the Commonwealth, an obvious exempt organization.
Correct. Correct.
Mr. Costello, I don't mean to beat a dead horse, but I take it if the retirement board invested in funds, or invested its funds in a real estate investment trust, that would be considered exempt.
I don't believe it would by statute, Your
So
Honor.
they couldn't invest in a company that invests in real estate.
If the legislature deemed it appropriate to exempt real property investments of such a retirement system, it would have to expressly provide so in the statute. It hasn't to date.
But the investments are exempted.
Investments in personal property are only.
But stock is personal property, isn't it?
Yes, it is.
So, and that's exempt?
It is.
So what about investing in stock in the building that you own?
Or
investing in stock in a corporation that is the 100% owner of a building?
Well, that gets to the other point of our argument, which we haven't addressed at all. The LLC actually owns the building, which is not the MRS and is not clearly the Commonwealth of Massachusetts. So for tax assessment purposes, local assessors are obligated by General Laws, Chapter 59, to assess property to the owners of record of real estate as of January 1. We have no discretion in determining to whom assessments would be issued.
All right, thank you, Mr. Costello.
Thank you, Your Honors.